Good day everyone, especially to Ms. Ria Kibir. I'm Gian Kapangpangan and I'm the last reporter of our group. So the first topic I'm going to discuss is about the Investment Priorities Plan or IPP. So on April 4, 2006, the Office of the President has approved the 2006 Investment Priorities Plan pursuant to Article 29 of the Omnibus Investment Code of 1987 under Book 1 of the Omnibus Investment Code. So this plan specifies preferred areas of investments that can grant certain benefits and incentives to investors who choose to invest in them. To avail these benefits, investors must adhere to the investment priorities outlined in the current IPP or the Investment Priorities Plan. So the Investment Priorities Plan or the IPP issued annually by the Board of Investments or BOI. So it is a list of promoted areas of investments eligible for government incentives in consultation with related government agencies and private sector. So consequently, the following activities related to tourism have been classified as priority investment areas. So first is the agribusiness. So agribusiness, it refers to the business activities involved in the production and processing of agricultural and fishery products, as well as the utilizations of their byproducts and waste materials for commercial purposes. So in simpler terms, it encompasses the entire process of growing, harvesting, and processing agricultural and fishery goods for sale, as well as finding ways to make use of any leftover or unused part of those products in a profitable manner. And next is the healthcare and wellness products and services. So this covers hospital services, medical and dental services, other human health and wellness products or services, retirement villages, medical zones, and related services. So this also covers the manufacture of drugs and medicines in accordance with the Philippine Drug Formulary of the Department of Health or the DOH, supplements limited to vitamin A, iron, and iodine for use in the food fortification law and herbal medicines. So the third is the information and communications technology. So this covers IT or information technology and IT-enabled services and ICT support services. So when we say IT-enabled services, these are services that utilize information technology to enhance or enable various business processes. So for examples of IT-enabled services include business process outsourcing or the BPO, customer support, financial and accounting services, data entry, transcription, and other administrative tasks that are outsourced to companies specializing in such services. So when we say ICT support services or the information and communication technology, this refers to the support and maintenance services provided for information and communication technology infrastructure. And the fourth is the motor vehicle products. So this covers the production and manufacture of motor vehicle parts and components, and manufacture or assembly of motor vehicles provided that the activity includes a program for the development of motor vehicle parts and components. And the fifth is the infrastructure. So this covers the development of infrastructures, telecommunications, logistics, and transport system, and mass housing. This also covers infrastructure projects under the BOT law or the Build, Operate, Transfer law. So this law provides the legal framework for government agencies to enter into public-private partnership or the PPP contracts with qualified private sector proponents for the implementation of government infrastructure or development projects. And next is the tourism. So this covers the development of tourism economic zones, tourist estates, eco-agri-tourism facilities, and the establishment of tourist accommodation facilities. So this also covers historic cultural heritage projects and services provided by tourist operators as endorsed by the Department of Tourism or the DOT. And another is the shipbuilding or shipping. So this covers shipbuilding, ship repair, shipyard operations, excluding the shipbreaking, and overseas domestic and ro-ro shipping and terminal operations. And next is the jewelry. So this covers the manufacture of the fine jewelry and costume jewelry. And lastly is the fashion garments. So this covers the production of fashion garments as endorsed by the Department of Trade and Industry, or the DTI. So fashion garments essentially refer to wearing apparel for a specific season with a distinct style and color based on the international trends. Next, I'm going to discuss about the Autonomous Region in Muslim Mindanao list, or the ARMM list. So the ARMM list covers priority activities which have been independently identified by the Regional Board of Investment of the Autonomous Region in Muslim Mindanao, or the RBOI ARMM. In accordance with EO 45A, the RBOI ARMM can grant registration and administer incentives to activities in the Investment Priorities Plan, or the IPP, provided that these are located in ARMM and subject to the general policies and specific guidelines. So the following have been classified as priority activities related to tourism under the ARMM list. So first is the export activities. So export activities includes the export trader and service exporters and the support activities for exporters. And another is the infrastructure and services. So this includes the public utilities and telecommunication with international gateways. So when we say international gateway, it is a point where telecommunication networks of different countries or regions are interconnected. It enables the exchange of voice, data, and other telecommunication services between different countries or regions. These gateways play a crucial role in facilitating international communication by allowing calls, messages, and data to be transmitted between networks located in different parts of the world. And next is the tourism, which includes the tourism estate, and another is the tourism accommodation facilities such as the hotels, resorts, and other tourism accommodation facilities such as the apartment, pension houses, tourist inns, and others. And we have the tourist transport facilities, which are the air, water tourist buses, and taxi or van. So we have here another priority activities which related to tourism under the ARMM list. So we have the development of retirement villages. So this shall include health and medical facilities, including amenities required by the Philippine Retirement Authority, or the PRA, subject to the guidelines to be approved by the BOI ARMM in consultation with the PRA, the Department of Health, and the Regional Planning and Development Office, and other concerned agencies. And lastly, we have here the ARMM priority and tourism areas. So listed below are the potential tourist destinations which need further exploration and evaluation for intensified promotions, development, and marketing. We have here the first area, which is the Sulu, and the second is the Tawi-Tawi, third the Lanao del Sur, fourth is the Maguindanao, and the fifth the Sharif Kabunsuan, and lastly we have the Basilan. So next, let's talk about the incentives. So under Book 1 of the Omnibus Investment Code, an investor may enjoy certain benefits and incentives provided that he invests in preferred areas of investment found in the current Investment Priorities Plan, or the IPP. So the following are the fiscal incentives. So when we say fiscal incentives, it refers to the measure implemented by governments to encourage specific economic activities or behavior by providing financial advantages or benefits to individuals, businesses, or organizations. So these incentives are typically included in the form of tax incentives, although they can also involve other financial benefits such as grants, subsidies, or exemptions. So we have here the fiscal incentives, other fiscal incentives. First, the income tax holiday. Second is the exemption from taxes and duties on imported spare parts. Third, exemption from wharfage dues and export tax, duties, imposts, and fees. Tax exemptions on breeding stocks and generic materials. And next is the tax credits. And lastly, we have the additional deduction from taxable income. So what is income tax holiday, or the ITH? So an income tax holiday refers to a temporary period during which individuals or businesses are exempted from paying income taxes to the government. It is often implemented as a government policy measure aimed at attracting investment, stimulating economic growth, or promoting specific industries in a particular region or country. So BOI, registered enterprise, shall be exempt from the payment of income taxes reckoned from the scheduled start of commercial operations as follows. So first, we have the new projects with a pioneer status for 6 years. Another is the new projects with a non-pioneer status for 4 years. And another, we have expansion projects for 3 years. As a general rule, exception is limited to incremental sales, revenue, or volume. And next, we have a new or expansion projects in a less developed areas for 6 years regardless of status. And lastly, the modernizations projects for 3 years. As a general rule, exemption is limited to the incremental sales, revenue, or volume. So the income tax holiday, or the ITH, is limited in the following cases. So export traders may be entitled to the ITH only on their income derived from the following. First is the export of new products, those which have not been exported in excess of $100,000 in any of the 2 years preceding the filing of application for registration, or export to new markets to a country where there has been no recorded import of a specific export product in any of the 2 years preceding the filing of the application for registration. And next, we have new registered pioneer and non-pioneer enterprises, and those located in LDAs or the less developed areas may avail themselves of a bonus year in each of the following cases. First, the indigenous raw materials used in the manufacture of the registered product must at least be 50% of the total cost of raw materials for the preceding years prior to the extension, unless the board prescribes a higher percentage. Second, the ratio of the total imported and domestic capital equipment to the number of workers for the project does not exceed to $10,000 to one worker. And lastly, the net foreign exchange savings or earnings amount to at least $500,000 annually during the first 3 years of the operation. In no case shall be registered pioneer firm avail of the ITH for a period exceeding 8 years. So next is the exemption from taxes and duties on imported spare parts. So this refers to a policy or provision that allows certain individuals, businesses, or organizations to bring in spare parts from foreign countries without having to pay the usual taxes and duties associated with importing goods. So these exemptions is typically granted to promote the repair, maintenance, or replacement of machinery, equipment, vehicles, or other goods that require spare parts for their functioning. So a registered enterprise with a bonded manufacturing warehouse shall be exempt from customs duties and national internal revenue taxes on its importation or of required supplies, spare parts for consigned equipment, or those imported with incentives. And next, we have the exemption from wharfage dues and export tax, duty, impost, and fees. So this refers to a situation where certain goods or commodities are granted relief or exemption from specific charges and taxes related to the handling and exportation of goods. So all enterprises registered under the IPP or the Investment Priority Plan will be given a 10-year period from the date of registration to avail of the exemption from wharfage dues and any export tax, imposed and fees on its non-traditional export products. So next we have here the tax exemption on breeding stocks and genetic materials. So tax exemption on breeding stocks and genetic materials refers to a provision in the tax code that grants certain tax benefits to individuals or businesses involved in the breeding and genetic improvement of livestock or crops. So the purpose of this exemption is to encourage and support agricultural activities aimed at enhancing the quality and productivity of livestock and crops. So agricultural producers will be exempted from the payment of all taxes and duties on their importation of breeding stocks and genetic materials within 10 years from the date of registration or commercial operation. And next, we have here the tax credits. So tax credits are a type of incentive provided by a government to encourage certain behaviors or activities that are considered beneficial to society or the economy. So they are designed to reduce the overall tax liability of individuals, businesses, or organizations. So first, the tax credit on tax and duty portion of domestic breeding stocks and genetic materials. A tax credit equivalent to a 100% of the value of the national internal revenue taxes and customs duties on local breeding stocks within 10 years from the date of registration or commercial operation for agricultural producers. And second, the tax credit on raw materials and supplies. So, a tax credit equivalent to the national and internal revenue taxes and duties paid on raw materials, supplies, and semi-manufacture of export products and forming part thereof shall be granted to a registered enterprise. And lastly, we have here the additional deductions from taxable income. So, when we say additional deduction from taxable income, it refers to the certain expenses or contributions that can be subtracted from your total income to reduce your taxable income further. So these deductions are in addition to the standard deductions or itemized deductions that individuals are eligible for when filing their income tax return. So first, the additional deduction for labor expense or the ADLE for the first 5 years from registration. A registered enterprise shall be allowed an additional deduction from taxable income equivalent to 50% of the wages of additional skilled and unskilled worker in the direct labor force. So the incentive shall be granted only if the enterprise meets a prescribed capital to a labor ratio and shall not be availed simultaneously with ITH. So this additional deduction shall be doubled if the activity is located in an LDA. And second, the additional deduction for necessary and major infrastructure works, the registered enterprise locating in the LDAs, or the additional deduction for labor expense or in areas deficient in infrastructures, public utilities, and other facilities may deduct from taxable income an amount of equivalent to the expenses incurred in the development of necessary and major infrastructure works. So the privilege, however, is not granted to mining and forestry related projects as they would naturally be located in certain areas to be near their sources of raw materials. And we have here the non-fiscal incentives. So when we say non-fiscal incentives, it refers to reward or motivators that are not directly related to financial compensation or monetary benefits. So these incentives are designed to motivate individual or groups by appealing to their personal values, emotions, and psychological needs. So we have here a non-fiscal incentives. First is the employment of foreign nationals. So a registered enterprise may be may be allowed to employ foreign nationals in supervisory, technical, or advisory positions for 5 years from date of registration. The position of President, General Manager, and Treasurer of foreign-owned registered enterprise or their equivalent shall however not be subject to the foregoing limitations. And second is the simplifications of customs procedures for the importation of equipment, spare parts, raw materials and supplies, and exports of processed products. So importation of consigned equipment for a period of 10 years from date of registration, subject to posting of a re-export bond, the privilege to operate a bonded manufacturing or trading warehouse, subject to custom rules and regulations. So here are the procedures for the issuance of Certificate of Registration under Book 1 of EO 226. So first, we have the official filing of a duly accomplished BOI form number 501 complete with supporting documents and payment of filing fee. Second is the evaluation of application and preparation of an evaluation report, including the publication of notice of filing of application, referral to private sector, and plant visit if necessary. And the third is the presentation to the BOI Management Committee. And fourth is the confirmation by the BOI Executive Board. And fifth is the preparation of letter advising applicant of the board action. And sixth is the applicant request for waiver on pre-registration requirements or applicant complies with pre-registration requirements. And next is the preparation and issuance of certificate of registration upon payment by applicant of registration fee. And lastly, the release of certificate of registration. And here are the documents to be attached. First is the copy of applicant's article of incorporation or partnership and bylaws. And SEC certificate of registration or the Security of Exchange Commission. And second is the copy of company audited financial statements and the income tax return or the ITR for the past 3 years or for the period the applicant has been in operation if less than 3 years. So for domestic existing and expanding projects whose existing operations are not registered with the board, this must be submitted unless waived by the board. And third is the copy of company's board resolution authorizing officer to sign in behalf of applicant enterprise. And lastly, the project report. And next, let's talk about the Special Investors Resident Visa Executive Order number 63. So the Special Investors Resident Visa issued pursuant to the provisions of the Omnibus Investment Code of 1987, as amended shall entitle the holder to reside in the Philippines for an indefinite period as long as the required qualifications and investments are maintained as provided for in Article 74 of the Omnibus Investment Code. The visa when issued by the Philippine Embassy or Consulate shall be issued with the following notation: Special Investors Resident Visa under the Omnibus Investment Code of 1987. So the Special Investors Resident Visa is a type of visa that is specifically designed for foreign investors who wish to reside in the Philippines. So the Special Investors Resident Visa is issued accordance with the provision outlined in the Omnibus Investment Code of 1987, which is a law that promotes investment in various sectors of the Philippine economy. So this means that the issuance and regulation of the Special Investors Resident Visa are governed by the provisions of this law. So the Special Investors Resident Visa grants the holder the right to reside in the Philippines for an indefinite period, which means that there is no fixed or predetermined time limit for their stay in the country. So in order to retain the benefits of the Special Investors Resident Visa and continue residing in the Philippines indefinitely, the holder must meet and maintain the certain qualifications and investments as specified in the Article 74 of the Omnibus Investment Code. So this article likely outlines the specific requirements and obligations that the investor needs to fulfill in terms of their investments and other relevant criteria. So, which means that, in summary, that the statement explains that the special investor's resident visa in the Philippines allows foreign investors to reside in the country for an indefinite period. However, the holder must meet and sustain the required qualifications and investment as provided for Article 74 of the Omnibus Investment Code in order to maintain the visa and residency status. So this executive order also grants incentives to foreigners investing at least $50,000 in a tourist-related project or in any tourist establishment as determined by the committee. Executive Order Number 63 grants the foreign investors a special investor's resident visa for as long as the investment subsists. The executive order also recognizes the right of the investor to remit earnings from his investment in the currency in which the investment was originally made and at the exchange rate prevailing at the time of remittance. So in case of liquidation, the investor is also allowed to repatriate the entire proceeds of the liquidations of the investments in which the investment was originally made. And lastly, the right of succession is also recognized. An investor may apply for special investors resident visa at the Philippine Embassy or consulate in his home country or place of residence. If already in the Philippines, the investor may file the applications at the Department of Tourism for endorsement for the Bureau of Immigration. And we have here the list of private lands. So foreign investors investing in the Philippines can now lease private lands up to 75 years. Based on the RA number 7652, entitled Investors Lease Act, lease agreements may be entered into with Filipino landowners. Lease period is 50 years and renewable once for another 25 years. So for tourism projects, the lease shall be limited to project with an investment of not less than $5 million and 70% of which shall be infused in said project within years from signing of the lease contract. And next, let's talk about the Special Economic Zone Act of 1995, a Republic Act of 7916. So the law provides for the legal framework and mechanism for the creation, operation, administration, and coordination of special economic zones in the Philippines, creating for this purpose the Philippine Economic Zone Authority or the PIZA, and for the other purposes. On October 7, 2002, the Department of Tourism or the DOT entered into a memorandum of agreement with PIZA that will grant special economic zone status to tourism development zones and tourism estates upon registration with PIZA, subject to the issuance of the required presidential proclamation. The PIZA shall consider for registration tourist-oriented enterprises to be located in PIZA-registered tourism development zones or tourism estates which are enclosed by the DOT as enterprises that will be established and operated with foreign tourists as primary client. So these are the incentives available. First is up to 100% foreign ownership of locator enterprises. Second, income tax holiday for 6 years for pioneer firms and 4 years for non-pioneer firms. If a non-pioneer firm is located in a least developed area, it shall generally be entitled to 6-year income tax holiday. And after the income tax holiday period, the option to pay a special 5% tax on gross income in lieu of all national and local taxes except real property taxes. And fourth is the tax and duty-free importation of capital equipment required for the technical viability of registered tourism activities. And fifth is the special investors resident visa. And sixth is the employment of foreign nationals. And lastly, other incentives as may be determined by the PISA Board or the Philippine Economic Zone Authority. So we have here the application of the law. So Republic Act 7922 was enacted establishing the Cagayan Economic Zone. Accordingly, any foreign investor who establishes a business enterprise within the zone and who maintains a capital investment of not less than 150,000 pesos shall be granted a permanent resident status within the zone. Such foreign investor shall have the freedom of ingress and egress to and from the zone without need of any special authorization from the Bureau of Immigration. So, such law is constitutional in accordance with the state policy, which provides from the Section 20, Article 2, 1987 Constitution that states the state recognizes the indispensable rules of the private sector, encourages private enterprise, and provides incentives to needed investment. So this law providing for the legal framework and mechanism for the creation, operation, administration, and coordination of special economic zones in the Philippines will be promote the flow of investors, both foreign and local, into special economic zones, which would generate employment opportunities and establish backward and forward linkages among industries in and around the economic zones. In addition, these special economic zones shall be vested with the status of a separate customs territory which shall be within the framework of the Constitution and the national sovereignty and territorial integrity of the Philippines. So next, let's talk about the joint venture. So in a joint venture, which similar to partnership, two or more persons bind themselves to contribute money, property, or industry with the intention of dividing the profits among themselves. So to constitute a joint venture, there must be an agreement to enter into undertaking in objects of which parties have community of interest and common purpose and performance, and each of the parties must have an equal voice in the manner of its performance and control over agencies use therein, though one may entrust performance to others. So a joint venture is distinguished from a partnership in such a way that a joint venture may or may not attain a juridical personality. If qualified as partnership under the Civil Code, it is taxable as a corporation, and if not qualified as a partnership, it has no juridical personality. So participants in a joint venture is organizing the joint venture deviate from the traditional pattern of corporation management. Just as in closed corporation, shareholders' agreements in joint venture corporation contain certain provisions which do one or more of the following. First is require greater than majority vote for shareholders and director action. Second, give certain shareholders or group of shareholders power to select a specified number of directors. Third is to give to the shareholders control over the selection and retention of employees. And lastly, set up a procedure for settlement of disputes by arbitration. So the usual rules as regards the construction and operation of contracts generally apply to a contract of joint venture, which has the force of law between parties and must be complied with in good faith. The legal concept of a joint venture is of common law origin. It has no precise definition, but it has been generally understood to mean an organization formed for some temporary purpose. It is hardly distinguishable from the partnership since their elements are similar community of interest in the business, sharing of profits and losses, and mutual right of control. So the main distinction cited by most opinions in common law jurisdictions is that the partnership contemplates a general business with some degree of continuity, while the joint venture is formed for the execution of the single transactions and is thus of a temporary nature. So the Supreme Court had had however recognized a distinction between these two business firms and has held that although a corporation cannot enter into a partnership contract, it may however engage in a joint venture with others. So we have here the application of the law. The country's largest property developer, Ayala Land Incorporation, will transfer the legal title of its 7,377 square meter property at Ayala Center in Makati City to K. Ali Manila Incorporation, the joint venture company it formed with Dubai-based hospitality group Kingdom Hotel Investment Incorporation. Ayala Land Incorporation said that the property is valued at 1.76 billion. The property is currently being used by Anson's department store, Park Square 2, and the public transport terminal. The assignor, which is the Ayala Land Incorporation, is the registered owner of a parcel of land located at the Ayala Center, Makati City, which it intends to convey and assign to the assignee, which is the K. Ali Manila, for the purpose of enabling the assignee to develop thereon a mixed-use residential and hotel condominium project. So in this case, the parties may declare the joint venture project as an investment priority plan and may apply at the Board of Investments for fiscal incentives, as the hotel project will help tourism in the country. So it must be noted that the tourism industry and related projects such as hotels continue to be among the top foreign exchange generators contributing to the growth of the Philippine economy. Next, we have here the management contracts. So in corporation law, it is an agreement under which a corporation delegates the management of its affair to another corporation for a certain period of time. So these are the following conditions. First is the approval by the board of directors and stockholders owning at least the majority of the outstanding capital stock. And second, whereas stockholders representing the same interest of both the managing and the managed corporation own and control more than one-third of the outstanding capital stock entitled to vote of the managing corporation, or where a majority of the members of the board of directors of the managing corporation also constitute a majority of the board of directors of the managed corporation, then the management contract must be approved by the stockholders of the managed corporation owning at least two-thirds of the total outstanding capital stock entitled to vote. And third is the no management contract shall be entered into for a period longer than 5 years for one term. And fourth, the aforementioned condition shall apply to any contract whereby a corporation undertakes to manage or operate all or substantially all of the business of another corporation, whether such contracts are called service contracts, operating agreements, or otherwise. And lastly, such service contracts or operating agreements which relate to the exploration, development, exploitation, or utilization of natural resources may be entered into for such period as may be provided by the pertinent laws or regulations. A management contract is an arrangement under which operational control of an enterprise is vested by contract in a separate enterprise which performs the necessary managerial functions in return for a fee. Management contract involves not just selling a method of doing things, but also involves actually doing them. A management contract can involve a wide range of functions such as technical operation of a production facility, management of personnel, accounting, marketing services, and training. Management contracts also have been used to a wide extent in the airline industry, and when a foreign government action restricts other entry methods. Management contracts are often formed where there is a lack of local skills to run a project, so it is an alternative to foreign direct investment as it does not involve a high risk and can yield higher return for the company. So we have here the application of the law. Hyatt Regency Manila is one of the oldest Hyatt properties worldwide since it opened its doors to the public in 1969. The deluxe hotels owning company Hotel Enterprise Philippine Incorporation has a management contract with the Hyatt International Corporation with headquarters in the US. So what are the possible reasons for engaging a foreign company to handle the management of Hyatt? So in this case, when Hotel Enterprises Philippines Incorporation, then headed by its president Jose Marichan and its vice president Elizabeth Char, engaged Hyatt International Corporation for the past 37 years is a management contract because that is part of the deal of having a Hyatt branded hotel in all the territories where the international hotel chain has engaged business. So the management contract can carry a number of conditions like provision of an expatriate, though not necessary, general manager and a team of experts to include an executive chef and other senior executives. It is important that the employment of expatriates be accompanied by the provision of the Filipino understudies, since this is normally reported by the Human Resources Director with the Department of Labor, Unemployment, and the Bureau of Immigration and Deportation. So the Hotel Enterprises Philippine Incorporation, on the other hand, is obligated to pay HIC management fees or percentage of gross revenues or net income depending on what is stipulated in the management contract. Hyatt Regency Manila ceased operating and did not renew its management contract with the HIC effective December 31, 2006. And next, let's talk about franchising. So a franchise is a privilege given to a dealer by a franchise service organization to sell the franchisor's product or services, including the trademarks and trade names in a given area with or without exclusivity. Such arrangements are sometimes formalized in a franchising agreement, which is a contract between a franchisor and the franchisee wherein the former may offer consultation, promotional assistance, financing, and other benefits. The franchisee must pay a franchise fee for such night. In addition, the franchisee is typically required to use the franchisor's product. So, a franchise is a license from other owner of a trademark or trade name permitting another to sell a product or service under that name or mark. More broadly stated, a franchise has evolved into an elaborate agreement under which the franchisee undertakes to conduct a business or sell a product or service in accordance with the methods and procedures prescribed by the franchisor, and the franchisor undertakes to assist the franchisee through advertising, promotion, and other advisory services. So, when we say product distribution, it is a form of franchising where owners of products allow other parties to sell or distribute their products or even use their trademark as a dealer. There is a minimal or no control operations, and the relationship is centered on the quality of products sold. And when we say the business format, it is a form of franchising used by 90% of companies involved in franchising. This is the reason why franchising is considered the most successful way of expansion worldwide. In business format, the franchisor, more than his registered trademark and products, has developed a business system that is made available for use to franchisees. Compliance to the business system is the core and essential element of the contractual relationship embodied in a franchise agreement. So the proliferations of several hotels in the country with international brands or names was made possible through franchising agreements. The same is true for certain international restaurants and coffee shops such as Figaro, Max, and is now engaged in franchising outside the Philippines. So a franchise agreement involves multiple licensing of intellectual property. Such licensing is governed by the rules on technology transfer agreements. So the term technology transfer agreements, it refers to contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product, the application of a process, or rendering of a service, including management contract and transfer, assignment of licensing of all forms of intellectual property right, including licensing of computer software except computer developed for mass market. Under Republic Act No. 8293, also known as the Intellectual Property Code of the Philippines, the term intellectual property rights consists of first, copyright and related rights, second, trademarks and service marks, third, geographical indications, fourth, industrial designs, fifth, patents, sixth, layout designs, layout designs, topographies of integrated circuits, and lastly, the protection of undisclosed information. So, the Intellectual Property Code mandates that all technology transfer arrangements must comply with the voluntary licensing of all intellectual properties in order to prevent or control practices and conditions that may constitute an abuse of intellectual property rights having an adverse effect of competition and trade. The Philippine taxes on all payments relating to technology transfer arrangement shall be borne by the licensor. So we have here the application of the law. So Joanne Perez is an entrepreneur who wants to have a restaurant of her own. After scouting for a couple of months, she decided to approach Pancake House for franchising. However, she wanted to incorporate some personal concept in the restaurants that will in effect alter drastically the true concept of Pancake House. So the question is, can Joanne modify drastically the business concept of Pancake House? So in that case, the answer is no. So, Joanne cannot modify the business concept according to her wishes. When she decided to acquire a franchise of Pancake House, she was essentially buying one whole system that has been tried and tested in the market. Drastic changes implemented can result in violation of the franchise agreement between the two parties. And now let's talk about taxes, or specifically taxes on income. So generally, active business income earned by individuals is subject to graduated rates of tax between 5 to 32%. Personal exception is granted to single individual or married individual judicially decreed as legally separated with no qualified dependents for 20,000 pesos, and head of families 25,000 pesos, and married individual is 32,000 pesos, and there is allowed an additional exemption of 8,000 pesos for each dependent not exceeding 4. So the active business income of corporation on the other hand is subject to a flat 35% rate. The tax rate will be reduced to 30% in 2009. So passive income such as interest, royalties, and dividends are subject to final withholding taxes, which are withheld at source. The applicable rates of final withholding tax vary depending on the type of income involved and the taxpayer. So corporation, including partnerships, are classified as domestic or foreign depending on the place of incorporation or organization. A domestic corporation is a corporation organized under Philippine laws, and a foreign corporation is a corporation organized under the laws of foreign country. So a foreign corporation is either resident or non-resident. The taxable income of a domestic corporation includes income earned from all sources within and outside the Philippines. A resident foreign corporation is one considered doing business in the Philippines and is taxed on net Philippine source income. The regular income tax rate is 35% of net table taxable income. However, to deter corporations that consistently declare losses or pay very small income taxes, the law requires corporation to pay a 2% minimum corporate income tax or the MCIT on gross income on annual basis beginning its fourth year of operation if the MCIT is greater than its regular corporate income tax liability. So the non-resident foreign corporations are taxed at 32% of the gross amount of the Philippine source income such as dividends, rents, royalties, compensation, and remuneration for technical services. So this tax is withheld at source. So foreign and local businesses in the Philippines that qualify and are registered for incentives can avail of income tax holidays and may be followed by final tax rate of 5% on gross income in lieu of local and national taxes if the business is located in a special economic zone. So international carriers doing business in the Philippines are liable to pay tax of 2.5% of its gross Philippine billings. So when we say gross Philippine billings, it refers to the amount of gross revenue derived from the Philippines in a continuous and uninterrupted flight in respective of the place of sale or issue and the place of payment of the ticket of passage document. For international shipping, the term gross Philippine billings means gross revenue, whether for passenger, cargo, or mail originating from the Philippines up to final destination, regardless of the place of the sale or payments of the passage of freight document. So we have here the application of the law. Mr. Von Bach is a German operator of a German international carrier doing business in the Philippines. So Mr. Von Bach has a revenue from the Philippines of 500 million pesos and a collection of 450 million pesos. And from the US, he have a revenue of 450 million pesos and a collection of 400 million pesos. And from the Germany, he have the revenues of 950 million pesos and 900 million pesos for his collections. So the question is, how much income tax must Mr. Von Bach pay? So in this case, Mr. Von Bach must pay 12,500,000 pesos because the gross revenue from the Philippine source is 500 million pesos multiplied by 2.5%, so the answer is 12,500,000 pesos. Next, we have here the value-added taxes. So a 12% value-added taxes is imposed on any person who in the course of trade or business sales, barters, exchanges, leases goods or properties, renders services, or engages in similar transactions, and who imports goods. The value-added tax is based on the gross selling price or gross value in money of the goods or property sold or bartered. And when we say percentage taxes, persons whose annual gross receipts do not exceed $550,000 are exempt from payment of value-added tax but shall pay a percentage tax equivalent to 3% on quarterly sales. Domestic carriers and keepers of garage shall pay 3% of their quarterly gross receipts. International air carriers and shipping carriers doing business in the Philippines shall pay 3% of their gross quarterly receipts. And for excise taxes, excise tax is imposed on certain specified goods and manufactured or produced for consumption in the Philippines for domestic sale or consumption or for any disposition and those imported. Excise tax is paid in addition to VAT, alcohol products, automobiles, and certain luxury items such as jewelry, precious metals, perfumes and toilet waters, yachts, and other vessels intended for pleasures or sports are all subjects to excise taxes. The liability to pay excise tax accrues immediately upon removal of the goods from place of production and manufacture. So we have here the customs and import duties. So customs duties are taxes on imports or exports. Importation begins from the time the carrying vessels or aircraft enters the Philippine territorial jurisdiction with the intention to unload therein to the time the goods are released or withdrawn from the customs house upon payment of the custom duties or with the legal permit to withdraw. So whether brand new or used, purchased or donated, an imported vehicle is subject to 40% customs duty, 10% for VAT or value added tax, and ad valorem tax from 15% to 100% depending on its piston displacement. Its book value serves as the tax base and not the purchase price nor the acquisition cost. The book value is sourced from universally accepted motor vehicle reference book such as the Red Book, Blue Book, and World Book depending on the origin of the imported vehicle. Spare parts sent with the motor vehicle are taxed separately. So next is we have here the travel taxes. So under Presidential Decree number 1183 as amended by PD 1205, Batas Pambansa 38 and Executive Order 283, Filipinos and other nationals traveling to another countries are required to pay travel tax before departure from the Philippines. So the following are required to pay travel taxes. First is the Filipino nationals, second, permanent resident aliens, and third is the non-resident aliens who have stayed in the Philippines for more than 1 year. And the following are exempted to pay travel taxes. So first is the Filipino overseas contract workers, second, the Filipino permanent resident abroad who stay in the Philippines in less than 1 year, or the balikbayan, and third is the infant, which is 2 years old and below. And we have here the requirements for exemption. So for Filipino overseas contract workers, these are the valid passport, employment certificate, valid overseas employment certificate from the POEA or the Philippine Overseas Employment Administration, and if hired through this agency, the OEC serve as the travel tax exemption certificate, and workers do not need to go to PTA for exemption. And another is for those directly hired abroad, a certificate of work or employment issued by the employer and noted by the Philippine Embassy or the employment contract authenticated by the Philippine Embassy or Consulate. And for Filipino permanent resident abroad, these are the requirements: copies of ID pages of passport and stamp of last arrival in the Philippines, proof of permanent residence in foreign country, which may be the official document issued by the foreign government concerned showing the grant of permanent resident status to the Filipino citizen. And for those between 18 to 60 years old and are employed, the Philippine income tax return for the previous year, which may either be an information return, BIR forms of 1701C or 1703 for those who do not derive income in the Philippines, or the appropriate ITR form prescribed by the BIR for those who derive income in the Philippines. And another for those between 18 to 60 years old and are unemployed, an affidavit of unemployment notarized by the Philippine Embassy or Consulate. And the requirements for exemption of infants are a photocopy of passport and certified true copy of birth certificate. And these are the individuals who are exempted from travel tax. First is the foreign diplomatic representative, second, employees of the UN and its agencies, third, U.S. military personnel, fourth, international career crew, fifth, the Philippine Foreign Service personnel assigned abroad and their dependents, sixth is the Philippine government employees and official travel excluding government-owned and controlled corporations, and another is the grantees of foreign government-funded trips, students with approved scholarships by appropriate government agencies, and lastly, the personnel of Philippine offices of multinational corporations not engaged in business in the Philippines and their dependents. So let's talk about Barangay Microbusiness Enterprise Law. So the Barangay Microbusiness Enterprise Law Act of 2002 was enacted to hasten the country's economic development by encouraging the formation and growth of barangay microbusiness enterprises, which effectively serve as the seedbeds of Filipino entrepreneurial talents and integrating those in the informal sector with the mainstream economy through the regionalization of bureaucratic restrictions and the active intervention of the government, especially in the local level, and the granting of incentives and benefits to generate much needed employment and alleviate poverty. So the Barangay Microbusiness Enterprise, hereinafter referred to as BMBE, refer to any business, entity, or enterprise engaged in the production, processing, or manufacturing of products or commodities, including agro-processing, trading, and services, whose total assets, including those arising from loans but exclusive of the land on which the particular business entity's office, plant, and equipment are situated, shall not be more than 3 million pesos. So here are the procedures when applying for registration as BMBE. So first, an applicant for BMBE shall go to the office of the municipal or city treasurer where the business is located. Second, the applicant shall accomplish BMBE Form 1 in triplicate and submit to the office of the municipal or city treasurer. And third, the municipal or city treasurer evaluates the application. An application shall be processed within 15 working days upon submission of complete documents, and otherwise the BMBE shall be deemed registered. And lastly, a registered BMBE shall be issued as proof of registration, which will be effective for a period of 2 years, renewable for 2 years for every renewal. So we have here the application of the law. So Mrs. Nita Naidas wishes to put up a resort in the city of Muntinlupa under the name of Neat's Garden and Swimming Pool. She has a capital of 25 million for the construction of the swimming pool and the other improvements therein. She wants to legally put up her business without going through expensive registration fees and subsequent expenses for labor benefits. So the question is, does her business qualify for the BMBE law? So the answer is yes. It is definitely advisable for Mrs. Naidas to register as a Barangay Microbusiness Enterprise or the BMBE. Under the Barangay Microbusiness Enterprise Act of 2002, a registered BMBE shall be exempted from the income tax for income arising from the operation of the enterprise. In addition, a registered BMBE shall also be exempted from the coverage of the minimum wage law. In this regard, registration shall be valid for and renewable every 2 years, and a registration fee not exceeding 1,000 pesos shall be paid to the local government unit concerned. And that's all for today. Thank you.